And I'm asking, is the sacking of P&O staff a justifiable business decision? The staff were left shocked yesterday when the business decided to sack 800 of them via a video message. The decision sparked outrage, with union members and former staff taking to the streets today in protest. P&O says that the decision was due to a loss of £100 million per year, which was not sustainable. So for our Great British Debate this hour, I'm asking, is the sacking of P&O staff a justifiable business decision? Employment lawyer for the Howard Kenny law firm, James Townsend, joins me now. So talk to me. What do you make of the decision by P&O and the way it was actually done?
Well, I listened to the Zoom call quite carefully. It must have been out of the blue. It must have been a shock for people. Nobody obviously likes to be given that news over Zoom. And I think from a PR perspective, it might have been a bit of a disaster. Fully understand the frustrations of the people. If you listen to what the Zoom call said, they said, look, we're going to be putting a settlement agreement forwards to affected employees. And you've got until the 31st of March to decide whether or not you're going to take that settlement agreement. What P&O seem to be saying is we're going to pay you more than your statutory entitlement. Now, what I don't know, and you don't know at this point in time, is what is contained within that settlement agreement. But what affected employees need to be thinking about are their contractual and their statutory rights. So each of them, because they haven't been given notice, they have a right to claim compensation for the period of notice that they should have been given. And that will be governed under their contracts of employment. We don't know what that says, but there are statutory minimums. Additionally, anybody who is made redundant is entitled to a statutory redundancy payment. If processes aren't fairly followed, claims for unfair dismissal may follow for those with over 2 years' service. And there are obligations to collectively consult in certain situations. But this is a really interesting case because we're dealing with ferries. We're not dealing with bricks and mortar. We're dealing with boats registered in foreign jurisdictions that travel international waters. So there are some territorial jurisdictions at play. There are special rules actually that apply to ships. About 20 years ago or so, there was actually an exclusion for ships. That's changed. P&O may be able to rely upon a specific exclusion, which means they don't necessarily need to inform the government in advance. But arguably, they still needed to collectively consult if the individuals and the ships are closely associated with Great Britain, as would appear to be the case. So when looking at the compensation that P&O should be offering staff, they should be compensating them for their notice payments, for their redundancy payments, potentially for up to a year's salary for any unfair dismissal claims, and potentially up to 90 days per affected worker. And no doubt the unions are going to be on top of this, and we're anticipating we're going to be seeing a lot of legal action.
Yeah, interesting, though, because I thought, and I know you did allude to it earlier, actually, that because where was the jurisdiction? Because they are, they're on a boat. So, sometimes I know people who work on boats and cruises and things like that. Some of them pay tax because they're offshore. How does that work then? I know they've got unions to protect their rights, but how does that work? There must be, there's a fuzzy area here, isn't there?
Well, the Court of Appeal looked at this question in a case called Seahorse in 2018. And what they said was, we're looking for a connection with Great Britain. So these are ferry companies. I mean, I take it they come in and out of places like Portsmouth, Dover, those sorts of places. The workers seem to be British workers. The test is what's the association. And so it would seem difficult for P&O at first grasp to get out of their statutory obligations. I mean, there are also provisions within the relevant legislation. It's a piece of legislation called TULCRA, which talks about, if there are exceptional circumstances, you can sack people sort of straight away without following the process. But it's not going to be likely to be applicable in this sort of situation. I mean, the company is owned by some Dubai-based wealthy business. I don't think there's going to be a business justification. So it is entirely possible that P&O are going to be on the hook for quite a lot of money here. It'll be interesting to see what defences they seek to run. But fundamentally, let's hope that they're offering decent compensation as they offered in their Zoom call yesterday.
Interesting that you mentioned about the owner, Sheikh, I'm not going to say the full name, but Sheikh Mohammed, who apparently his personal fortune's around about 10 billion. But they are justified in some respect because they've been losing 100 million year on year, and they're basically saying it's not viable. That's a realistic thing to say, isn't it?
Well, let's assume for the moment that the legislation does apply. UK legislation sets out quite clearly that you're going to look at each ship as a different establishment, and assuming you've got more than 20 employees on each of those ships, you should be consulting for 30 days. If it's more than 100 on each ship, it should be 45 days. He's got to work by the rules, and if he doesn't work by the rules, then he should expect to get his wallet out and pay quite significant compensation. So, we are in a time where there have been lots of businesses who've been in an unfortunate situation of having to make redundancies, but they consult with unions, they elect workplace representatives. There is a meaningful consultation. You're supposed to look at ways of avoiding redundancies, and that wasn't done. There was an announcement out of the blue, and actually what was really interesting about that announcement was they talked about the fact that they're going to be outsourcing jobs. So there are employment lawyers out there who are saying, well, maybe there's a piece of legislation called TUPE that might even apply, and there's possibly some outsourcing arguments, and possibly further compensation can be claimed by the unions on behalf of their workers through that route. So it's going to be really interesting to see how the unions now pursue matters on behalf of their members, and much is going to depend upon the package that P&O are offering. Clearly, if they're offering a very generous package that covers staff, a lot of staff may take it, sign the settlement agreements and waive their rights to bring claims. But we need to wait and see what's in that package. That's a piece of information I'm afraid I don't know.
Very high-risk strategy to sack people in that way or make them redundant like that without even mentioning it. But starting out on Twitter, listen, James, it's a pleasure to talk to you. That's James Townsend. He's an employment lawyer at Howard Kennedy. Right. Well, this is GB News on TV, online and on digital radio. I'm Nana Aquir. I know we'll be going shortly to the statement. In a statement, P&O Ferries said the business would not be viable without making swift and significant changes now. We've made a £100 million loss year on year, which has been covered by our parent company, DP World. This is not sustainable without these changes. There is no future for P&O Ferries.